So now, please welcome Professor Dwight Duncan.
Nice to be back.
It's wonderful to have you back with us.
Likewise.
I'm happy that Southern New England School of Law is waiting at least 2 weeks more before tying you up, so you wouldn't be able to join us. And I'm also delighted to know that you work closely with one of our Harvard graduate student groups, the Harvard Society for Law, Life, and Religion. Yes.
Yeah.
And you're, of course, one of our most distinguished members of the Prolife Legal Defense Fund.
Well, you know,
Massachusetts.
law professors are expert at taking credit for other people's work. And that's over the years, that's pretty much what I've done with respect to the students at the Harvard Law School Society for Law, Life, and Religion. They've done amazing work, research, and writing on a whole host of issues.
That is wonderful, because I know their contributions have been in briefs in many of our noted cases.
No, that's right. Actually, maybe it wasn't this past term, but the previous term, one of our briefs was actually cited in the U.S. Supreme Court decision, a Pro-Life Legal Defense Fund amicus brief.
Yes, was that the case from New Hampshire?
No, actually, that was the case from Oregon case.
Yes.
That's right, and it was mentioned in Justice Scalia's dissenting opinion, unfortunately, but still, it was nice to have their work recognized, I think.
Well, the last time you were here, we were looking forward to the court and Aont, the case from New Hampshire involving parental notification.
That's right.
And then subsequently, we were all concerned about what was going to happen when the Partial Birth Abortion Ban Act went back before the court. And I'm amazed that things have been handled as expeditiously as they have. And I wonder if that is due to Chief Justice Roberts' extraordinarily well organized approach to things.
Well, you know, he is a very significant new influence on the court, and of course as Chief Justice, and also in view of his youth, I think he is bringing a kind of vision of the court and its work to bear. For example, he's spoken often about his view that it would be good for the court to speak unanimously as much as possible, and so that there not be these very splintered views of the law. But I think in service of that, you know, philosophy to judicial philosophy to foster unanimity as much as possible, thus to make it clear that these are legal questions and constitutional questions as opposed to political questions in which there are factions and so on. He's also propounded a philosophy of judicial moderation and restraints, such that, you know, the way he put it at his confirmation hearings, that if it's not necessary for the court to decide, it's necessary for the court not to decide.
I think I like that.
No, I think I do, certainly. I think it's a more modest understanding of what judging really is all about in a democracy like ours, and you know, that I don't think the judges are supposed to be platonic guardians who know everything and decide everything. If that were the case, then why do we have a democracy?
Exactly.
So I think it's very important that judges stick to the rules, and, you know, and as laid out in the laws and the Constitution, and you know, from my perspective, I think one of the dangers of sort of loose talk about a living Constitution is that it basically makes of the Constitution a kind of blank check for judges to just impose on society their own values and preferences and politics, and I think it's very important that not happen, precisely because of the rule of law and because of the very notion of constitutional government. The whole notion of a written Constitution is it's important to have certain things spelled out in black and white, and, you know, that are understood according to the meaning of words at the time that they were enacted, so that there's, you know, some definable meaning there, and it's not just judges imposing on the rest of us their own value preferences. I think that's quite illegitimate, and incidentally, there's a sense in which I think this notion of a living Constitution makes of the Constitution a kind of dead letter.
Yes.
Because then what the words actually say and what they mean don't matter.
Don't matter at all, because there will be a different meaning with a different judge.
Right. And so I think my sense of it is that Chief Justice Roberts is making a conscious effort, I think, to restore this understanding of what judges are supposed to do, you know, and it's more important, it seems to me, at the highest levels of the U.S. Supreme Court.
In the wake of Ayotte decision, it seemed so strange to me that with the political change in the makeup of the New Hampshire legislature,
right,
instead of taking advantage of a favorable interpretation,
they repealed it.
Yes, this seems so extraordinarily obtuse and self-defeating and against the interests of the citizens of New Hampshire. It's difficult for me to quite comprehend that kind of thinking.
Yeah.
And of course, those who opposed it were in no position to do anything about it because they had lost voting control of the legislature.
No, that's right. I mean, I don't think, even though my specialty is the law and the Constitution, I think there's no substitute for grassroots political work, and you know, there's no shortcuts, really, I don't think. And so, but what Ayotte was important for was it was basically indicating that the U.S. Supreme Court was not going to strike down a parental notification law on its face because of the absence of a health exception, and basically the criteria for mounting what are called facial challenges to legislation, which have been successfully used for decades, really, by Planned Parenthood in striking down, you know, pro-life legislation around the country. That now the criteria are much more restrictive, I think, in terms of what kind of showing one needs to make before one can prevail in court on a facial challenge.
Well, you know, some people do not look back far enough to notice how the foundation for that was constructed. Do you remember Professor Cyril F. Means from New York University?
Oh, by reputation, sure.
Yes, and he is the one who essentially established that foundation because he chose specific ones of his law students, particularly the ones who became the editors of the law review that he considered most outstanding, and they were the ones who created the foundation of laws from which all of those decisions eventually descended. And I find that not strange, but a lot of people who somehow thought all of this just came out of nowhere did not look at the foundation.
No, I think that's right. One of the interesting things that's happened over the past, probably 25 years is that the pro-life side has really kind of caught up to the other side in terms of litigation strategy. And, you know, there are a number of pro-life litigation outfits around the country. You know, locally we have the Pro-Life Legal Defense Fund, but I mean there are national organizations as well. Groups like Americans United for Life or the American Center for Law and Justice, things like that really, I think, learned a fair amount from the American Civil Liberties Union.
Well, they should have.
Yeah, because they were prevailing in courts.
Prevailing, and the litigation instincts that they were indulging simply had no limit.
No, that's exactly right. And but now I think, well, two things have happened. One is I think the Supreme Court now, while it's pretty evenly split, the hope is that with Chief Justice Roberts there to persuade Justice Kennedy, who's